and getting involved in these different organizations can really be a benefit. Tulsa Title and Probate Lawyers has been around forever. I think I've been a member for over 30 years. We have a meeting every month up at the Summit Club. They provide the most incredible lunches. We used to meet at the Tulsa Club when that was something that existed that a lot of you probably don't even know about. But anyway, at every luncheon except Christmas, at every luncheon there is either a half an hour or a full hour of CLE presented. And it's presented by people who are very knowledgeable in their fields, and it's really enjoyable because, again, you can sit down and have lunch with different people each time you go. You form friendships and you get to know attorneys, and other than that context of being adversaries, because most of us, if you do any trial work, whether it's family law or civil law or criminal law, you are in an adversary position, and so naturally that makes the hair on the back of your neck come up, and it makes you be proactive for your client. But again, you can be as proactive as you want. You still should be courteous, and you still should be civil with each other, and you should be civil with the court. These professional organizations are really a great opportunity to get to know other lawyers. The Young Lawyers Association within the TCBA, it's remarkable. They put on great programs. They have great social hours. I mean, if you don't participate in that and you're a member of the Tulsa County Bar Association, anybody can go to those, even us old geezers. We can go to these social functions if we want to. And they're a great time. And it's a good way, again, to get to know people on a more personal level to where you establish some relationships other than being adversaries. Did you all get a chance to read this letter? This is a real letter in a real case. I mean, it's hilarious. I love it. I am sorry that a hurricane hit Houston. I'm sorry that I had no power or water at my house as a result. And Robbie was telling me of a situation where she was dealing with a lawyer that was in much the same situation in Houston, and it's like, oh, my deposition or the fact that your life's been torn all apart. Let's keep the big picture in mind. Anyway, I love this letter. Gerald Hilscher sent this to me, and I sent it on to Judge Thornbrew. I saw him at the donut shop and told him that he said I'd love to have a copy of it. Okay, standards of professionalism. These were approved, quote, by the Oklahoma Bar Association Board of Governors on April 20th, 2006. This was the result of 3 or 4 years of pretty intensive work by local attorneys. There was a committee that was appointed. Judge Wiseman served on that committee. I served on that committee for a while. I can't remember the gentleman's name. He's a silver-haired lawyer from Oklahoma City, and he always wears a bow tie, and he always joins the Tulsa County Bar Association. Robbie, you made... Okay, he was an active member of this committee. I just want to hit a few of the highlights. I hate to read to people because I know you can all read, but I'm just going to try and hit a few of what I think are the highlights. At 1.1, we understand that the law is a learned profession and that among its tenets are devotion to public service, improvement of the administration of justice, and access to justice for our fellow citizens. And that's critical because that's part of our mission, is to provide legal service. Everybody, I have a saying though, I like to pick my pro bono. I don't like for my clients to pick my pro bono. You know, and I try to provide service to 1 or 2 people, or as whatever I can, every year that I know there's not a Chinaman's chance that they're going to be able to pay their bill, but they need some help in a particular area, and maybe I can help them. 1.2 is the penultimate. A lawyer's word should be his or her bond. We will not knowingly misstate, distort, or improperly exaggerate any fact, opinion, or legal authority, and will not improperly permit our silence or inaction to mislead anyone. You know, you can omit as well as you can commit. So and a great example of this is that when you're arguing a case, if you know there's authority that's adverse to your position, and it's a decision of the Supreme Court or the Court of Appeals that's been released for publication, you have a duty to address that problem. You have a duty to say, I understand there's Jones versus Smith out here, Your Honor, but I think it's distinguishable because of this, or we're trying to make new law, or we're arguing for an extension of existing law that may be contrary to this case. it doesn't do you any good in the long run to just sit there and be silent on that kind of an issue, because hopefully sooner or later somebody's going to find that case or bring that up, and if you have knowledge of it again, you should address it. Further, if this occurs unintentionally, if there's an unintentional oversight and is later discovered, it will be immediately disclosed or otherwise corrected. That's our responsibility to ourselves and to the public. 1.8, we will not make statements which are false, misleading, or which exaggerate, for example, the amount of damages sought in a lawsuit, actual or potential recoveries and settlement of the lawyer's or the lawyer's qualifications, experience, or fees. Then you have Section 2 on lawyers' responsibilities to clients. You know, this is where you're exercising your independent judgment is so important, because there are so many times that clients will say, I want you to do this, or I want you to take this position. And you have to just look at them and say, I can't do that. I cannot do that. And sometimes, this is a poor example, but when I was a young pup, I had, you're so eager for clients, and I had a guy come in. I'd never done a bankruptcy. I've never done a bankruptcy. But I had this fellow come in and wanted to do a bankruptcy. And I said, okay, I'll talk to you. Came through lawyer referral. So we're sitting there, and we're talking about exemptions and everything. And he said, well, I've got this car, but I'll just hide it. It's like, what do you mean, hide it? Well, I'll just hide it. I won't disclose it. Anyway, he ended up leaving my office, and he was upset with me for telling him, you can't do that. I can't do that. He got mad and left. Well, I'll find somebody that will. Maybe he did, maybe, I hope he didn't, but anyway, that's where you have to exercise your own independent judgment, and you know the law, they don't. If a client wants you to take a position that you know is wrong, you just have to tell them, I'm sorry, I just can't do that. We will be loyal and committed to our clients' lawful objectives, but will not permit our loyalty to interfere with giving the client objective and independent advice. That's what I was just talking about. And I'll give you another example. I went and met with some potential clients last night where there's a subdivision, there's some serious drainage problems, and there are several homeowners, and they're all affected in different ways, different degrees. And I met with Mr. X first and talked with him, and then I've seen the hydrologist report, so I know what the problems are, and I looked at him because I know that they wanted me to meet with some other people as a group. And so we did, but when I sat down, I told him, I don't think I can represent all of you, because your house is unique, it's got a value. Whoops. Your house is unique, it's got a value. Your problems are different than these problems, are different than those problems. And when I left, I told him, if I got involved and there's a pie of money here, and I'm saying, okay, I'm going to get you every dime I can get you. But then I'm telling you that I'm going to get you every dime I can get you. And maybe I can't get both of you everything you deserve. So I told him I would be glad to represent the first people that I talked with. And the other people had already seen a lawyer from Oklahoma City anyway who had talked to the group. And when I left, I told him, there's no hurry for you to make this decision, and you'll make the right decision. Whether you hire me, you hire this fellow from Oklahoma City, or you bring in somebody else. But I couldn't sit there and say, okay, I can represent all of you, because I know I can't. I couldn't do each individual homeowner the job, and I know this other attorney had talked about, economies of scale and all that, and I couldn't see it because your home's different. I've got to prepare your case with your home based on your facts, and then I've got to turn around and prepare his case for his home based on his facts. So I didn't see the savings. But again, that's just one man's opinion, but that's an example, I think, of being able to say, this is my judgment, and I have to live with my judgment. $2.5. We will reserve the right to determine whether to grant accommodations to opposing counsel in all matters that do not adversely affect the client's objectives, lawful objectives. And that's my example with Ken. Just got on the phone. There's no reason that hearing had to be that day. It's been pending now for, as most motions for summary judgment do, they pend forever. We will advise our client, if necessary, that the client has no right to demand that we engage in abusive or otherwise offensive conduct, and that we will not engage in such conduct. Folks, these are the rules that govern our conduct. These are things that we need to look at and take very seriously. 2.11, I do a little bit of mediation. My partner, Hugh Rainier, does tons of domestic mediation. When involved in an alternative dispute resolution process, we will participate in good faith and will not use the process for the purpose of delay or for any other improper purpose. If you're going to take the time and the effort to go to mediation, which mediation is wonderful because it gives the clients the opportunity to participate in fashioning their own remedy. And especially in family law, how many of y'all practice family law? Okay, you know, I know we know, you go down there, you might get 30 minutes with the judge on a particular day if you're lucky, and then you get continued. Hugh tried a case in Creek County last year that took almost 6 months of going over there for 3 hours and going over there for 4 hours, and then, you know, the judge has emergency hearings, and your client's sitting there paying for all that. And mediation, if you both go in there with the idea that I'm not going to get everything I want, but we're going to get this resolved, mediation is great in all areas, but you have to participate in good faith. And you know, how many of you have been to federal court settlement conferences? The first thing, you know, when you walk in, the judge says, at least this is what John Leo used to say, if you're looking for justice, you're in the wrong place. We're here to try and settle this case. And most of the time when he said that, the client's mouths dropped open. They're like, wait, I want justice. Now, what we want to do is to get you out of a very bad situation with as well as we possibly can. And that usually means, you know, give and take. I'm always amazed when you go to those settlement conferences and you're dealing with insurance carriers and the first offer on a serious case is like $5,000. And that always amazes me because it always gets everybody's blood pressure up. Anyway. Lawyers' responsibilities to other lawyers. We will be civil, courteous, respectful, honest, and fair in communicating with adversaries, orally and in writing. I will say this, things have changed from when I first started practicing. And now if you make an agreement with counsel, follow it up with a letter. Sometimes people just forget. I mean, it can be perfectly unintentional, but we had a case where we sent a settlement check in, and I called the attorney in Oklahoma City, and I said, you know, we've got an answer due tomorrow, and I know you're going to dismiss. And he said, well, since it wasn't a trust account check, it was a client's check. He said, we need to give it time to clear, which, yeah, that's right. But he wrote me a letter and said, Dear Larry, you do not have to file an answer. That we should be able to know that this is resolved by this date, and if there's any problem, we'll let you know. I put that in the file. If I agree to extend discoveries for somebody, it's pretty common somebody will call you and say, hey, come on, you know, you got kids, you got activities, you got weddings, you got illnesses, you got whatever. Will you give me an extra 5 or 10 days? If somebody asks me for an extra 5 days, every time I'll say, no, I'll give you 10 or 15. Because chances are, if I say 5, you're going to be calling me wanting another 5 or another 10. So let's just do 10 or 15 days, and that way you've got the time to get everything done. But you followed up with a letter. Golly, especially in today's world with emails, you know, it's so easy. You just pop out a little email and bingo, and then you print it out and put it in the file.